So this is actually really, really interesting. We've got issues with local planning and building at the moment with a scheduled monument, right? And I've been doing loads of petitions, and I've been raising the whole issue with the council, which they don't know about because the council wasn't formed till 1973, just around when they got rid of the courts of aldermen and the mayor, and the whole council was figured into the sort of like criminal justice was part of the council, like on a separate rota, like committee, right? And when you were petitioning Parliament or having big meetings with people to Parliament, or people signing large numbers of petitions to Parliament, right, which we will be doing with our scheduled monument for certain, which we have done, right, up till 1986, it had to go through the council, really. Well, it could go through a court, but it would be the council because it would have been like the mayor and alderman type thing, and the council stamp and seal it off to say that you're officially doing it, and you have to have meetings. So if you're petitioning Parliament, it's effectively like, if you have a judicial review now of a council decision, it's official, right? It's in the legal system. And it's like the council know that you're doing a legal action. Like if you're having a judicial review, it's like properly listed at the court, and they will like stop or suspend, like if they've passed any building projects or plans, or even if you challenge them, within a certain time, they can stop or halt them, or even change their order, right? Because you're going to a court for a judicial review. But you can do private bills to Parliament to oppose the council, if you don't agree with the council and you want to get an act of law to override the council, or kind of like take the powers away from the council, or dispute, like get the government to change by law of the country, beg your pardon, the land usage rights, or permissions or consents, because you can get it done by an act of law of England, particularly if it's something, if it's just like private building and planning, right, and it's got nothing to do with anything to do with the country, it's private. But as soon as you touch upon public bills, then it's like to do with it becomes national matters and the public business, because like a scheduled monument is the public business of the whole country. That's why you've got an act for them, the Scheduled Monuments Act. It makes it into the business of the whole country, right? So it's never ever a local matter only. The Scheduled Monuments Act makes it into the business of the whole country, so anyone can, complain to the Secretary of State, particularly in Scotland and Wales, when you can petition for those enforcement orders. So like people can petition the Secretary of State or Minister for enforcement order, but in England you're going to be able to enforce it yourself with like a claim, interest in future ownership they made. But the Secretary of State in England can also withdraw and repeal the orders, the consent orders, and clearly we've got the right to petition for that in England anyway, under the normal right to petition, right? But then you've got all these surrounding issues. So if you are doing a matter which is public business to Parliament, right, if you're pursuing it like by petition legally, the council would know that, just like the council would know if you were doing a judicial review, right? But it's, instead of a judicial review, it's actually it's a legal action to Parliament, right, in the public business. So like those e-petitions are petitioning Parliament, no matter how simple they appear or basic, right? And you don't even need to go to a newspaper now, like the Sun newspaper, because the e-petitions are published, made available to the public or a section of the public at large in whatever form or whatever means. They're actually, the government have the website to publish them, so they are published and made available to the public. That's how you can share them, share the link and put them in Facebook groups, like in the Huddersfield Then and Now group. It's got 23,000 people. I think it's got as many people in that group as the Huddersfield Examiner and local newspapers got, right? So that's making it available to the public at large, or a section of the public, in whatever form and whatever means, right? Now, there were 6 acts with like the Seditious Meetings Act and the Tumultuous Petitioning Act made it so you got to put things in the newspapers or give notice, and the council had to like officially seal or stamp it off if you're going to Parliament. If you've got meetings or large numbers of people signing, if you're just doing it yourself, if it's like 5 or 10 people, right, and they sign it, and you've just got a very strong case based on compelling evidence, like just legal reasons, you can petition Parliament and you don't need all these consents or permissions, but you're still doing it. So it's like if you do a judicial review, it might only be like 2 people bring the judicial review with strong evidence. It's going to a court, right? They didn't have a meeting about it, and it didn't need to be put in the newspaper, or the newspapers probably might report on it anyway. But the council know that you're doing a judicial review, right? Now, the thing with Castle Hill is that we were doing about Fenny Bridge. Now, Fenny Bridge is very close to Kirklees Park, on the perimeter of Kirklees Park, right? And then the council had allocated some land for building houses, and I complained about it, and I said that I wanted it to be added to the protected land for Castle Hill and Kirklees Park. And, one of the main reasons is this: when you're on Penistone Road, and when you turn, when that road's all countryside and beautiful on the area, and there's a beautiful little cottage there, and then there's a sign saying Castle Hill, and you turn off that road. So people coming from the M1 or Huddersfield Centre going to Castle Hill, that's one of the main routes to Castle Hill. Besides, like, you've got the bottom of Newsham, which is the university, when the river, you can't really do anything about that now, it's already urban. But then you've got, like, you go from Wharfside, it's called Aspley Wharf, right? From Aspley Wharf, you can go diagonally up there, right? But people coming from the M1, if they're coming south from the north, and if they get off at junction 38 or any of those junctions, when they're coming in towards Huddersfield and Castle Hill, right, and they go through Shepley Village or wherever, if they're coming from Sheffield or somewhere like that, right, and then that's the main bottom road, really, the main bottom road from Castle Hill, which has still actually got some countryside to it, right? I mean, there's a little, very tiny bit where there's an off-licence shop at the bottom of Lepton, Fenny Bridge, which is actually near where our councillor, Alison Monroe, lives, right? But, I mean, if you turn off the main road there where that little cottage is, that's where they've put the little sales house for the, but when they're selling the houses now, they've just started doing it. I didn't know they'd start doing it because I haven't been out for ages, but I knew about it from councillor's Facebook page, and I put in opposition to it. I never go into the council because, when you're doing petitions to Parliament or doing, something proper legal, I mean, that's the whole point of submitting the objection. It's on the record. What's the point? And people they're given notice to it. The councils are supposed to take it into account, right? You don't have to go in there and plead like, Simon Armitage did, particularly if it's a petition and it's already published, right? We're having a lot of problems with the e-petitions team at the moment, though. That's another one of the problems, but they're only kind of new and modern, really. There's only been a petitions committee since 2015. There wasn't a petitions committee since 1972, right? And the 2015 one's new, right? There hadn't been one for a very long time. And this e-petitions team is very obstructive. I've put a very extensive and detailed complaint in against them now because we're being obstructed. Paul Davis is on that e-petitions committee, and he was a councillor for Kirklees, a Labour councillor, Paul Davis, if he's pro for building around, Huddersfield, how can he be impartial, I don't know how he can be, but anyway. So when you turn off that Penistone Road, it's one of the last remaining countryside junctions, which is what people are welcomed in when they're coming to Castle Hill when you turn off a main road, right? So, okay, if they're coming down past the, Yorkshire Sculpture Park, if they get off at junction 38, there's some countryside there, right? And if you're coming over from, Armenbury Village, right? Obviously, when you get to well, Armenbury Village itself is built up, but it's got a very old pub and things like that, you know, traditional. And actually, there's houses quite a way up that road. There's houses all the way up that road from Armenbury Village until you actually nearly get to Castle Hill, literally to the bottom of the footpath stairs, right? It's only the other side at the Golden Cock pub, which is Fenny Bridge, right? No, it's Farnley Tyres. Farnley Tyres. So the Farnley Tyres side of Castle Hill is the only village which is still a village, but it still is a village. And then you've got that road from there coming round, which they built the cemetery on, which they had to get rights for that. I would have objected to that cemetery. I think you've got to go to Parliament to get cemeteries built, and I don't know how anyone didn't manage to object to that cemetery being built there, so close to the site. So really, those few junctions are when you're already literally upon the site. All those junctions which have got countryside coming round from Farnley Tyres are literally, you're already upon the site already, right? But the one at the bottom of the road, but it's where there's a golf club on that road, right? The main Penistone Road, when you turn off there, right, to welcome people to Castle Hill from a main road, that is probably the last final main trunk, main road, right? I think that might even be maintained by the government, because, you know, local councils maintain the roads in local areas that aren't trunk roads, but that's a trunk road, right? So it might actually be either side of a main trunk road, right? But that's the last beautiful little countryside bit that welcomes you as a turn off a main road to come to Castle Hill, when you welcomes you into the area, right? And it is a beautiful little junction just when you turn, and councils don't appreciate things like that at all, really. They just don't have any sentimental value. And what that, you know, the actual corner that the field's on, just next to the tiny little cottage, right? They've put a sales house there. They thought, oh, this is a nice little spot. It's like when you go camping and, well, where shall I put my tent, right? You know, this is a nice little spot under a tree, right? It's like, oh, the place that's got their planning permission passed, right? At the side of that road there, which is the last countryside and fields, which they've started digging it up, right? When you turn off, they've put the sales house. Oh, isn't this a pretty little sales house, right? That is like grabbing hold of your nipple and twisting it, right? Like biting your nipple, right? That, right? Oh, there's a nice little beautiful cottage there. We want a nice little beautiful sales house thing in the corner, right? You know, I'm absolutely devastated with that. I'm furious with it. And up where we live, where there's another beautiful field on a corner, right? A nice little field where the farmer cuts, which is one of the, on the corner of like sort of, it's like Knotty Lane, right? They've gone and put the sales house signs and implanted them with metal posts and concreted them, half on the pavement and half in the actual farmer's field, which I don't know how they managed to get away with that. Two of them blocking the view. They're plastering stuff everywhere. I mean, I think it's worse than graffiti artists going around, you know, because at least with graffiti artists, it's only on the surface. These people are putting massive physical metal signs in. They're highway standard signs, those, and they're not even like a normal highway standard sign. It's like the heavy duty highway sign that they've put in, and I'm actually furious about it, you know. And this video was actually, you know what, I started this video off about Dadid Lammy, you know, because he's just gone and reduced the jury trials, right? And this Criminal Libel Act here, 1819, it's not actually been repealed. I just read it and it said it had been repealed, ironically, right? And this is not relevant to Kirklees Council now, but it's worth mentioning just things that the government are up to, right? It said that it was repealed in 2010, but it isn't repealed in 2010. There's various changes and modifications being made to it, some in 1967 as well with that Criminal Law Act, but it doesn't show you the original, right? It hasn't actually got the original, it's only got the latest revised, right? So this is the latest revised version, which has got the changes, right? And how they've repealed it is by putting the in Northern Ireland here. So they've put in every case in Northern Ireland, right? So it's like in every case in Northern Ireland, right? In every case in Northern Ireland in which any verdict or judgment by default shall be had against any person for composing, printing, or publishing any blasphemous libel, right? So this would be Keir Starmer now, you know, sort of like going against the Protestant faith, you know, like Charles has sworn in to defend the Protestant faith, right? You know, a lot of things the government are doing at the moment will be considered blasphemous, right? You know, Starmer's got all these religious champions that, as people are saying, are opposing our religion. But I'm not like joining religion now, but this is the important part here. Or any seditious libel lending into bringing into hatred or contempt the person of His Majesty or the government, but then it says, and Constitution of the United Kingdom. So this actually here is really important, and Constitution. MPs used to swear the oath was to uphold the liberties and freedoms of the realm, right? So when they swore the oath, it says to uphold the freedom and liberties of the subjects, which includes, like, you know, the Bill of Rights. But now the oath says that it's just according to law. So it says, I will serve, you know, His Majesty, faithful, you know, servant, etc., according to law, right? Which is all the laws. But it used to actually specifically say to uphold the freedoms and liberties of the subjects, right? Which is our rights, including the right to petition and so forth, right? If there's much left of it. But here it says that you're not even allowed to encourage people against the Constitution of the United Kingdom. Well, Magna Carta is to the right to have jury trials, and it's still in force, right? So to try and get rid of jury trials or even reduce them, right, is actually going against the Constitution of the United Kingdom. But remember, this is only for Northern Ireland now, right? This is only for Northern Ireland. Ironically, they haven't even got the original available, so I'll have to find it on the Statutes website or somewhere. Wouldn't it be great to see the original? So Dadid Lammy, he says for Northern Ireland. Is he reducing the jury trials in Northern Ireland? Apparently, it is. You're not allowed to speak. According to this, if it's in force in Northern Ireland, you're not allowed to speak against the government. So, I mean, another thing to say that's really important and significant is if you type in republic.org.uk, Graham Smith's campaign, you know, he's been, you know, going down with the crown. He's been shouting down with the crown in front of the king, right? You know, and he's been getting loads of people to turn up at all of the events that Charles has turned up at, and he's doing like down with the crown, right? I don't think you can do that in Northern Ireland, according to this. I don't think that you can do that. I'm not sure, because if it's a petition and you've got the right to petition, you might be able to do it. But you see, 1688 Bill of Rights said that you can petition, you know, the king without being prosecuted, all of the subjects. So I don't know whether or not republic.org.uk, I mean, I've done a parody for Charles, but this is since 2010, right? It's not in England. So since 2010, even this doesn't apply, right? So there's definitely no question about it. With this repealed, you know, like, and those seditious meeting acts repealed on top of the 1688 Bill of Rights. I don't know how they're going to figure in for the treason laws, but, you know, apparently it's the right to petition. I think that republic.org.uk definitely, you know, they're doing it, you know, it's all official, because it's like, it's all official activities now without a doubt, because they've been in the press and, you know, the police and the government. So whatever Graham Smith's doing with republic.org.uk. But you see, Dadid Lammy, if this was in effect in England, to even, you know, ask the public if they want to, you know, get rid of jury trials, you see, that's something going against the Constitution itself, right? I I don't know if David Lammy would have been able to do that. I don't think he can do it in Northern Ireland now, although, apparently it's actions of government. But this is the thing, like under the EU law, under the Human Rights Act, they've just challenged Priti Patel. I've said that, what Priti Patel did was legislating government, right? And she can't be challenged because it's not an act of a public authority, according to Section 6 of the Human Rights Act 1998. She's not acting as a public authority when she makes a prescribed group and puts it into a schedule of an act, right? But the thing is that I said that they shouldn't have brought the judicial review against, did I say Priti Patel? I meant Shabana Mahmood, right? Shabana Mahmood has put that prescribed group in to the schedule for the Terrorism Act, and that's not an act of a public authority by doing that, but they still have this judicial review. So it's like, when we do our petition campaigns, we're meant to be protected, and this is why the courts don't seem to uphold it anymore, because of that EU. They seem to think absolutely anything and everything can be challenged by this incompatibility with a convention right. So, like, the criminal and civil procedure rules at every level of court, actually, because the normal criminal procedure rules as well have got all these challenges you can have. If anything is against a European Convention right, you can challenge it, right? But that's only against the European Convention right. But they're saying they can challenge MPs in Parliament and lawmaking because they challenged Shabana Mahmood for putting the schedule into the Act, right? But yet that's not an act of a public authority, but they're saying that they can still do that, because the justice can send any act of law back for scrutiny, right? So surely what David Lammy is going to be putting into the law, right, I don't think he can do it in Northern Ireland, because it's against the Constitution of the United Kingdom, and Northern Ireland are part of the United Kingdom, and this is still in effect in Northern Ireland, right? But up till 2010, this was that, beg your pardon, F2, I think, there, Northern Ireland, is that the one that is just F2? So that's how the Act's not repealed, right? Like the whole Act, it's not like, we're repealing this whole Act out of existence. By changing the words F2 to Northern Ireland, right? And he's only done that by Coroners and Justice Act 2009, right? He's made the whole Act into Northern Ireland. He says transformed it from an act. This is like, if I'm wrong about this, you can call me out, right? But, I don't think I'm that stupid. What he's done is he's actually changed the wording of the Act, right? This is like, I think this is when Gordon Brown took over, or around that time, because it's to do with the Constitution Reform and all that, Constitution Reform Act, etc., right? F2 there, F2 words inserted. Also, he put them in to change the meaning of it. So he didn't say the United Kingdom and change it to Northern Ireland. He didn't say anything. He says in every case in which a verdict or judgment, right? So he's made it so it only applies to Northern Ireland. So Lammy definitely can't change the Constitution of Northern Ireland, where everyone's got a right to jury trial, only in England, because this prevents Lammy from doing it as well. What I'm getting annoyed with is this, right? All the constitutional rights of England, like the right to petition, they can't be challenged in the courts, okay? They're not allowed to be challenged in the courts. You can't challenge Parliament in the courts, or even question it in the courts, and you've got to have a leave of court to even mention it, right? They can use committee reports for evidence. Like if there's a committee report, like it's a record, right? They can use a record now to check things without having leave of court, like committee reports to have a look what happened or to prove what happened, right? But they're not allowed to intervene in proceedings. They can't intervene in or make judgments on proceedings, which is our messy civil processes, right? Which is why you've got the right to petition and the courts can't intervene or get involved in it. It's proceedings under the High Court of Parliament, right? Now, that means that, don't you think it's ridiculous, therefore, that, if David Lammy does anything as David Lammy, the Chancellor, right, and, head of the Justice, Minister of Justice, right, isn't it ridiculous that, a court can, criticise him or challenge him if it's incompatible with the EU, the convention rights in the EU, which is what the protesters did with Shabana Mahmood, for putting those prescribed groups, right? But the courts can't question Lammy on, for example, going against this act or changing the legislation, right? But it's actually, I'm sure that, look, right, there were laws that applied to the government. And this is what the government don't get. There were laws. There were the things that the government can't do, like in the in Article 2 of the EU European Convention, right, the right to life. It says that the government cannot have killing or dying unless it's to do with criminal procedure, criminal sentence or criminal procedure. You can't have it in civil law. And this is the whole argument with the Assisted Dying Act now, in Kim Leadbeater MP, right, who's an MP of one of the MPs in our local area, right? And, the Scottish Government have just rejected the Assisted Dying Bill the other day, and I'd actually put a criminal complaint in against Kim Leadbeater to the police. I'd actually complained about her for misconduct in public office, because it clearly is against the EU law, right? The government can't do it. They passed it in Jersey, but I don't know if the King signed it off yet. And I complained to Jersey Police about it, and I've done 2 big petitions to government straight away when they did it, because there's actually, when they prove the compatibility, they put a declaration and said this is compatible with the convention, right? But it isn't, because what they did, I've explained this in another video and I don't want to go over that again, but I basically showed how they've been fraudulent. They drew attention away from Article 2. They buried Article 2 in it and only did a really short paragraph on it, which wasn't really that explanative around Article 2. And then they filled in a really long, extensive document with stuff to draw attention away from Article 2 that they can't do it. And then they put a Switzerland case example where someone has got the right, to end their own life or do whatever they want themselves, or the opinion of the person if they don't want to live in respect to their own conscience. But that absolutely has got nothing to do with Article 2 in EU law, which says that the government cannot take people's lives and cannot have a process which takes life except through criminal procedure, right? That's got nothing to do with what the person wants or doesn't want or can and can't do, right, in respect to their own life and their own conscience. It's purely what the government can and can't do, and what the government is allowed to do and not allowed to do, right, including the courts, right? Not the person. The government can't have a law. The government can't have that Assisted Dying Act, right? Because it's not criminal law. It's civil law. Now, there's got to be something. You can't have it so the government can break all these laws and things they're not allowed to do in our own constitution of our country, but they're going to break in the EU, but we can call them out on the EU law when they're breaking it, right? Well, how ridiculous is it when we've got constitutional law of things that have to be upheld and kept in law and cannot be contravened, and the government have even got to uphold it, but we're not allowed to call them out on it when they violate it. We can only call them out on violations of EU law, right? Like, convention rights. But yet, this is like, when the courts are prosecuting us illegally for petitioning. Now, there were all these acts and all these laws put a lot of heavy restrictions in, but they were only mainly supposed to quell rebellions and riots, like Cromwell, right? Oliver Cromwell and the Civil War. They weren't supposed to stop you actually doing causes to Parliament, and they weren't supposed to stop those causes being legally privileged and protected. They're still legally privileged and protected when you're doing them properly, right? And when you're not amassing rebellion and armies, right? And that's what all these laws had to go through the council and everything, particularly when you're having large numbers of people. I don't think you ever had to have it sealed off or stamped by the council if you were just petitioning them yourself. But that would be if you're petitioning the House of Commons, right? With just 5 people, it's still got to be equal to, like, you know, the council have got to acknowledge it similarly if you're doing a judicial review. But, you know, who communicates with the council when you're doing a judicial review? Because the council don't do the judicial review, right? You apply to the court. But, like, you know, I think you've got to give notice to the other party, right? Send them a letter or something. But we did give notice to the other party, you know, when we're doing petitions to Parliament. I actually put them in the objections. You know, I recorded them in the objections, and I told the local councillor and put them on the councillor's, you know, Facebook page and emailed them. I'm told Kirklees Council, you know, and, you know, we are publishing it and circulating it now because, you know, even the Huddersfield Examiner has got the same amount of the Huddersfield Examiner circulation now is only the same circulation as what members are in that Huddersfield Then and Now group, which has got 23,000 people. Like, you know, it's somewhere around that, you know, not the exact number, but not far off. And I won't put it in the newspaper now because they're charging us VAT when we're not going to pay VAT, right? There is an act on stamp duty in these acts, they're called the 6 Acts, right? The 6 Acts. One of them is to do with stamp duty, to do with, like, pamphlets and things, but we've got the modern law, the Value Added Tax Act 1983 and the Value Added Tax Act 1981, or was it 1986? I think it's 1983 and 1991. 1990, or was it 1994? It's the Value Added Tax Act. Is that Value Added Tax Act 1994? Well, both of them. There's one in the mid-80s. That's for certain. So the Value Added Tax Acts now have got exemptions for political bodies that are not for profit. So, like, that includes, like, your petition campaigns because you're forming a body, right? And, like, if you've got a not for profit, you know, campaign group. So we are covered for value and stamp, but I think the Value and Stamp Duty Act was part of these 6 acts. So, I mean, I actually started recording this. I'm like, I'm going to raise this with the government for Dadid Lammy, right? Because I wonder if Dadid Lammy is doing it in Northern Ireland or not. But I don't think he can, according to this. So you've got to keep up the Constitution of the United Kingdom, right? Says, or the government and Constitution. Well, that's Magna Carta, right? So even if Lammy was trying to get the country to back him up, you know, to take away rights under Magna Carta, then surely that's going against the Constitution of the United Kingdom. But that doesn't apply to England now since 2009, 2010, when they made it into only Northern Ireland. But that's definitely still, I think, in law now, right? Just to try and keep tabs on Northern Ireland, I suppose. But I don't know how Graham Smith will go on with his republic.org.uk in Northern Ireland. Does it fall under the right to petition or not? And then does that mean that Lammy can and can't do it? How can Lammy not be called out on this, right? But, you know, they're calling out Shabana Mahmood when she's putting things into legislation, into schedules, right? Which they're saying, oh, it's incompatible with a convention, right? Why aren't they calling Dadid Lammy out and saying it's not compatible with the Constitution, right? At least in Northern Ireland. Which I don't know if Lammy's thing applies to Northern Ireland or not, but we'll soon find out. But George Galloway's just talked about it. Maybe I should draw this to the attention of George Galloway. Maybe I should tag him in it. Maybe George Galloway can call him out on it. But George Galloway's not even in England at the moment. So there's 2 things in this video. I've put the Dadid Lammy thing in this video, and then I've also put the thing about our local council in there and the local building and planning, which is sort of a separate matter. But anyway. Oh, it says other than by lawful means here. And I'm really being unprofessional now. It says other than by lawful means. So that's by petition. As by law established. hatred or contempt on the person or His Majesty or the government and Constitution of the United Kingdom as by law established. So that's Magna Carta, right? But everyone's always supporting Magna Carta. Don't you notice that it's quite the opposite of this? Like, you've got all these campaign groups and all these strange groups who are doing a lot of Magna Carta stuff, but they're always supporting it. All of the groups that you've got, right, are always supporting Magna Carta and complaining that it's not being upheld, and also like the Bill of Rights. You never get any of these weird groups that are against it. The only weird groups that are against it are actually the government themselves, right? It's always like the government who are against the Magna Carta and against the Bill of Rights, and the people who are trying to uphold it and defend it. If anyone is trying to spread things against it, it says except by lawful means. Well, okay, the government are using lawful means to change it, but are they even supposed to be changing those particular laws? Because, the confirmation of the Charter says that it shall remain in force for perpetuality, forever. His Majesty's government established in the kingdom, as by law established, or either House of Parliament, or to excite His Majesty's subjects to attempt. Oh, he says attempt. He says the alteration. Well, you can't. How can you alter it unless you use lawful means? How can you alter it, right? How can you alter it unless you use lawful means? How can you alter it except by lawful means? Lawful means. So, but going through lawful means is like, if you're doing a petition properly and not having an illegal uprising or rebellion, if you just go and get an army and act against the government without due process of law, observation of due process of law, right, which is what the right to petition is. But here it says that, or to excite His Majesty's subjects to attempt the alteration. To attempt the alteration. To attempt the alteration of any matter in church or state as by law established. Otherwise than by lawful means. Right, well, this is the thing, right? The main thing of this is this, right? It's saying that it can be altered, but it means that, what are they saying that you're going to do? Are they saying that you're going to go break into the Tower of London and go get the rolls and just alter them or burn them? Like Cromwell melted down, Edward the Confessor's crown or something like that, whatever he did, right? He did do the coronation crown was destroyed, right? Because the Charles II had a new one made, right? I know that. Stuff like that, right? Things like that, I mean, how are they going to attempt the alteration? But this is when you're getting into the confirmation of the Charters and Magna Carta saying that it shall be kept, and not changed. Unfortunately, from 1948 onwards, Queen Elizabeth, they started repealing parts of Magna Carta and changing them and things like that. And I don't know whether they can do that or not, because she got the Charter of Liberties as well. The Charter of Liberties is 1100, and the Charter of the Forests and Magna Carta, 1215 it was written, but 1275 is when it was put into proper legislation of the country, not just the King John and the Barons dubious thing. It's actually put into the law of the country, 1275. But then they had the confirmation of the Charters, which confirms all of the Charters. But there's arguments whether that confirmation of the Charters includes Magna Carta as well as the Charter of Liberties and Forest, right? I'm sure there's got to be something dubious to excite His Majesty's subjects to attempt the alteration of any matter of church. But that means, or state as by law established otherwise than by lawful means. So, like, you know, you've got to, like, you know, bring cases to Parliament properly and lawfully. But can it be attempted? Can the alteration be attempted? Can the alteration even be attempted? Can the alteration even be attempted? So this is like Criminal Libel Act 1819, and so therefore we'll go to the confirmation of the charters now, right? So this only applies to Northern Ireland since 2009, 2010, F2, right? Let's get that clear, right? I'm not saying this is in force now here in England, but it is in Northern Ireland. Can Lammy attempt to alter the constitution in Northern Ireland? That's the, you know, should he be attempting it anyway? Well, this was all about the promotion of it. This was mainly about even trying to incite people towards it, or get the idea in towards people's heads or the public, right? I actually wanted to make this video for specific things, right? But now this is great. I've actually just done this, right? Because when I was petitioning the Jersey government, right, I sent the petition in the post for free. I was going to pay for it, and I'm like, well, it's one of the King's dependencies, and they've got the King's mace in their government. Apparently, it's one of the original maces from when Charles II, it's from the date of Charles II, right? It's going back quite a long time, from the 1600s, the mace in the Jersey government. And I was like, shall I pay for the postage or not? And I'm like, well, no, it's still the King's government, and I'm still one of His Majesty's subjects. So I thought I'll put they've got this little thing from the, they've got this little, well, the clause in the standing orders, right, it basically tells that you can post them for free, right? And in Erskine May, it says that it can be posted for free when you're doing petitioning, sending them backwards and forwards to government or to MPs. Now, I just thought that was a law of Parliament, right? But it's actually in a proper act of law. And whereas it's expedient to authorise the conveyance of printed newspapers and packets in between the United Kingdom and His Majesty's colonies free of charge of postage, but it's also got for the votes and proceedings in Parliament, printed votes and proceedings. So petitions are votes and proceedings. Your petitions are votes and proceedings in Parliament, right? It's actually quite a long act, this. It's got, and this is, do you know, like when you don't pay VAT on newspapers and things like that, there are rules for posting newspapers in the post, like, because apparently they've got to be open at the sides. I think that's why they put strings around them, you know. Even when you get the newspapers, like at the off licence, and then they send the ones back that aren't sold, have you noticed that they put string around them? Like at the shop near us, you know, which has got quite a lot of newspapers in it. The ones that aren't sold, you know, like they wrap them, don't they? They put them outside to be picked up, and they've got string around them. Or that's how they do it where I am here. I've always wondered about that. I just thought it was easy to pick it up by the string, you know, like to pick the bales up, right? It says they've got when you're posting and sending newspapers, they can't be covered up in this act. That's quite amazing and interesting. So this is all to do with us sending our petitions for free as well. So it's called the Postage Act 1834. Now, 1834, that's before even the Parliamentary Papers Act was made in 1840, and before the rules for petitioning were even put in 1842. So this is this is like early 1800s, just as even the standing orders for Parliament, you know, like the books that Parliament even published for their own rules, and like Erskine May and all those things only emerged in the early 1800s, because before that, like, most of the rules and resolutions were in the journals, in the parliamentary journals. Like when they made a rule or law for procedure, it was in the journal. Like they collected them all together in the committee reports from all the journals, right, when they started making all these rules officially published. I think that some of the standing orders go back to the 1600s, but they were very, very basic. Like there was, like, you know, very minimal and then it's when they were starting doing things like building in construction bills and acts, when you had to have rules for, like if you're building a railway, you've got to have all the maps and the geography maps and the plans and the architectural drawings and all that type of thing. That was all introduced earlier on, because, it's not just like a complaint, a petition of grievance, or a judicial complaint. When you're putting acts of law through for things like land, they usually have like, technical drawings and things like that, because it's if you're proposing a bill, right? If you're getting a bill or act of law put through and passed, right, because it usually says like, from point A to point B, which is 365 metres south of, this location or the corner of two named streets and all that type of stuff. If you're putting a bill through Parliament, it needs, this is like when you're doing private bills, right? But in the public business, generally, or if you're petitioning, to try and lobby governments, in the public business, your MPs, that's why MPs are employed, right? You get loads of signatures to get your MP, to try and call for Parliament to do something. Then Parliament, you're trying to get Parliament to do it on behalf of the public, right? Which is like, when the current government, the current Labour Party introduced bills, they're doing it on behalf of all the Labour Party members, right? They've got control of government or whatever, that type of thing. But this is really actually significant. So it's actually the Postage Act 1834, that's when the rules come in for, like, definitely don't have to pay for things in the post, not votes and proceedings. So here we go. And actually, that last act that I just talked about, it's not even up on legislation.gov website by the looks of it. That's one of the acts that they haven't put up on there. I thought that I had that act on there because it's quite an interesting act. It's quite an interesting act for, the law of the postal services when it comes to posting things for free and exemptions. I don't even know why. Do you think that that's why in the Representation of the People Acts, like candidates in an election can post for free one, like not repeated, one, they can post one representation in the local ward for free? So it's like, if you are in an election for a ward, you're not going to post it anywhere else because they're not voting for you, right? But if you're voting in a ward, and you can't have like multiple, like keep sending things out frivolously, because that's like kind of like making it out of the postal service like repeatedly. But you can have one, so like you can have that's your communication, right? You can have one post. This is what Graham Moore complained about in the Runcorn Helsby by-election, because they were saying that his leaflets and flyers didn't get delivered, or some of them, like, and that was one of the things that got called out. His flyers didn't get delivered for the election. So this is the confirmation of the Charters 1297. Now, this was made a number of years after the actual proper Magna Carta of 1215 was made into law, right? I think it was 1275. So 75, 76, 77, 78, 79. So that's 4 years after Magna Carta becomes officially the legislation of the country, and not just kind of like some sort of anomaly of, the barons and King John. Because this is the legislation government website. Now, this confirmation of the charters, we're going to look at it now, but it's pertaining also to the Charter of Liberties, which is 1100, and the Charter of the Forest, because Magna Carta retains the Charter of the Liberty and the Forest as well in perpetuality. So now the thing is, after 1948, the Queen Elizabeth government, they started doing changes and amendments, which I don't even think they can do changes or amendments at all to these confirmation of the Charters 1297, right? You see, there's the original. It's not going to show us the original. It's only got the latest version. Variant reading. Rules repealed by Wild Creatures and Forest Laws, 1971. So that suggests to me, right, and I'm not being professional here, I'm just being like, this is intuition. That's got to have something to do with the Charter of the Forests, right? Wild Creatures and Forest Law, 1971. Did they just do that act in 1971 to try and they desperately wanted to try and do something they couldn't do. So hey, let's put something into the Charters and Forests, Wild Creatures and Forest Acts. Statute Law Revision 1948. See, I told you it was 1948. See, I actually do talk sense and reason. I told you 1948. So they wanted to do this Statute Law Revision and then we've got Statute Law Repeals Act 1969, and then there was a Criminal Law Act 1967 as well. So it's actually under Queen Elizabeth when they started getting into this business of touching on these charters. I don't know if we can find a copy of the original. It says the original was not in English. Edward, by the grace of God, King of England, Lord of Ireland, and Duke of Guyenne, to all those that these present letters shall hear or see, greeting. Know ye that we, to the honour of God, it's not much of honour to God in the Christian religion when they're actually, try to make praying and banished in public. That would be blasphemous, really. That would have been blasphemous as well under that other act. Of God and of Holy Church and to the profit of our realm have granted for us and our heirs that the Charter of Liberties, of which were made by common law assent of all the realm in the time of King Henry our father, shall be kept in every point without breach. And we will that our justices, sheriffs, mayors, and other ministers which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points. So that's like, it specifically says in judgment in all their points. So that should be like in front of a jury. So like, the specific to being pleaded in front of them. So that you're getting juries definitely involved in that straight in there, right? In judgment in all their points. That is to wit the Great Charter as the common law. So that's like the 1100s Charter of Liberties. Not a lot of people know about that act because it's not talked about. So F1, I think it was supposed to say the Charter of Liberties and Charter of the Forest, right? But it doesn't necessarily say Magna Carta. But this is made, the confirmation of the charters is made a couple of years after Magna Carta, right? So that F1 words repealed by the Wild Creatures and Forest Act 1971. So did it just say the Charter of the Forests? Certain rights of the Crown with wild creatures. Also, it was actually mainly, let's see, enactments repealed. Oh, so the first one here is Charter of the Forest. And then confirmation of the charters. Charter of the Forest, the whole statute so far as unrepealed. So they didn't actually repeal the Charter of the Forest because you can't repeal it. You're not going to be able to repeal it. Confirmation of the charters in chapter 1, the words and the chapter of the forest, where the first occupying with the words and the charter of the forest for the wealth of our realm. But this is the thing, right? This is the thing. What, they haven't repealed the whole of Magna Carta, and actually Magna Carta is still in force. They're not allowed to repeal the Charter of the Forest or the Charter of the Liberties. Yet they've modified them, but it said it should be kept in. It says they shall be kept in every point, right? Well, they're not keeping them in every point, are they? They aren't keeping them in every point at all. Right. So here we've actually got Magna Carta 1275, which is on legislation.gov.uk. Right. Here we are. So this is proper law. This is not like the 1215 Magna Carta. This is like 1275 Magna Carta is actually made into the legislation of England, although they're not going to show us the original. Got the latest available. So they've taken a lot of it out, as you can see, right? But no free man shall be taken or imprisoned or to be disseised of his freehold or liberties or free customs or be outlawed or exiled or any otherwise destroyed, nor will we pass upon him nor condemn him, but by lawful judgment of his peers or by the law of the land, right? We will sell to no man, we will deny or defer to any man, neither either justice or right. So there are some arguments in this, because I've been over all this before. I've done this ages ago, like a few years ago now. If you get the original wording and the original version, which is like there's some arguments over the actual words and lettering, right? So this is the word "or" here. So I think Lamb is trying to make out that they can be judged by the law of the land, like in front of a magistrate, without their peers, right? But those peers have to be like, they're also witnesses as well, I think that's got something to do with having to have witnesses. The Clarendon Assizes, the Assizes of Clarendon, I think were the first grand jury. The first grand jury was at the Clarendon Assizes, and this is actually when you had people who were trustworthy in the law, but they were all meant to be kind of affluent people, supposedly, who went round and found out about crimes and informed the courts about them, right? And they ended up becoming the grand jury. So when you've got a grand jury chosen and they're assessing and checking, you see, I think all of the cases that the sheriff brought in and that got prosecuted did get looked at by a grand jury, even without you having a when the king's courts come round and you've got the justices on the circuit, they call a jury together, right? And they had these grand juries, and then apparently it was just before that Ethel Margaret Self case in 1936. I think it was something like 1934, because I only read this the other day, that it was the last grand jury, and they hadn't. It ended up where by the time they got to 1934, they were just summoning them and getting them to approve the charges through ceremony, and they weren't really doing much of the investigating work or going through the evidence and deliberating themselves like they were supposed to do to scrutinise charges, right? So that was the last of the grand jury. And And I don't know if that's what the normal jury now has turned into, this kind of like, you just got 12 people called in and sit in a box and swear the oath and then sit in front of the case and hear it. I don't know whether the grand jury were involved in the petty sessions and the magistrates' court checking cases. If they were, that would mean that you got a right to, like, your peers checking on petty sessions as well. So therefore, if they remove them from petty sessions, you haven't got peers involved in every single part of the proceedings. You've only got this, like, magistrates, although they're meant to be voluntary magistrates, aren't they? But this is suggesting, like, the law of the land can be applied anyway, which is how you can get fined. How can you even get how can they take money off you for a parking ticket? Is by the law of the land, right? So when you get a parking ticket and you got to pay it, right, or else you have to go to court, that's by the law of the land, right? In that they can't accept the fine off you, right? They're not even be able to, like, send you a speeding ticket or a parking ticket and you accept the charge and then, say I'm guilty by post and then them apply a conviction or a fine by the law of the land, right? If it didn't have this word here, if it didn't have that word there, or, right, they wouldn't be able to give you a parking ticket, right, without a jury or without some sort of grand jury or something, like the people from the community, not just like the accusers, right? The people processing the council. Because otherwise you're getting back to, like, lynching mobs and things like that. And this is why you've got to have a matter of... The observation of due process 1368 is like matter of record and original. So, when the council are sending fines out and something, they're, everything's set in writing. They can't just have a policeman, say, you're a criminal, and then, put you in prison without, things being taken into proper account. The word account. Says his peers, though. So that's not the Lord's, right? He says his peers, though. I don't necessarily think that, if you're in another area, like if you're on holiday in Scotland, right, and you commit a crime, they're not your peers, but supposedly they're trying to make out that, they're at your level. They're sort of like, like, if you're working class, then it's still working class because they're your peers, right? But they're not members of the House of Lords, right? They're not like, barons, etc., because the barons get their own peers to judge them, right? Which they've even sort of tried to get rid of that now and abolish it. Is this meant to be that, you could argue that this could say that could mean, and this is a, this is beyond the scope of this video now, because this, you could even argue that, it had to be someone, like people who even know you, like, people from your own town or your own area or whatever, but you don't really know everyone in your own town, you could even say that it's your own friends, your own circles, people who know you, right, assembled together, but then there would be prejudice, I suppose. But I think that's what Graham Moore's talking about in his videos, Graham Moore says that, you get people who know a person and, say, like, is this the sort of behaviour that this person would come out with? That's the basis of those parole petitions. I showed you a parole petition the other day in a video, and I got it out in front of the camera and I showed you it. And it's got signatures of, like, people from the community who vouch for the behaviour and conduct of that person, that they are, that they should be released, early on parole or whatever for their good behaviour or standing. That really is his peers, right? So that parole petition, right? The petition for parole, which I've got, it's an American one though, signed in 1934, I think, or 1932 or somewhere around that time. That is actually the true his peers, because, like, there's people who are vouching for your good behaviour and conduct, from your local area or community, right? So that actually is, like, definitely peers who sign those parole petitions. whether or not that's what you're entitled to for justice or not, or by the law of the land. So you don't need them if you get like if the law is applied directly, because then, lynching mobs could just say that, someone's done something that you don't like, and then you just go and get some people and grab them and lock them up or hang them or God knows what, take their money from them, right? But they might not be doing it according to the law of the land, so it's not by, it's not even the law of the country that they're applying. They're just doing what they want, right? But David Lammy is getting into changing the law of the land, right? And he's claiming that he's doing it through lawful due process. But apparently, some laws can't be changed, but they have been changed. This is the thing: they changed the Charter of the Forests, right? And it was a Charter of the Forest that they said that you couldn't change, but they did it because of royal matters. But he definitely says it should be kept in every single point, right? So, I don't think it doesn't say that the confirmation of the charters applies to Magna Carta, but Magna Carta was always called the Great Charter, or, the Magna Carta. Why would they make the confirmation of the charters, and Magna Carta is a charter, 1275, 4 years after it? Why would they do that and keep the other two? It seems that who gets to choose whether it's by your peers or by the law of the land? Anyway, hold on a minute. So you see, it says no, petty sessions did not have grand juries. Petty sessions were summary courts, meaning justice was pronounced swiftly by justices of the peace without a jury, right? According to law. So already that, according to the law of the land or by his peers, they've already got those separated or else you wouldn't even be able to have normal petty sessions and summary crimes without a jury. And then, they got rid of the grand juries who were actually looking at the evidence and checking it, and then made it so that they just sit there and are sworn in, and everything is presented to them framed by the prosecutor. Anything the prosecutor says or the law that the prosecutor comes out with, but it was the jury who was supposed to look at the evidence and facts themselves, and the jury who could ask for, they actually were active, like the court staff, in asking for facts or looking for facts or deliberating between each other and looking at documents and seeing if there was enough to convict someone on it, if it was a sound conviction or not. And now they've just got them sat there, told to go sit there, and I don't think they actually looked at the law. I think they only looked at the evidence and facts. But they already reduced the function of what it's meant to be, to them. Just you'll sit there and we'll tell you what happened, what the Crown Prosecutor comes out with, and you can't look through the documents and deliberate. So they've already reduced the function of the grand jury, right? To you just sit there and listen, right? And we'll tell you what's going on. We'll tell you what's happened, right? When they wheel out the judge in his chair sits there, and the prosecutor comes in and the prosecutor decides, what's going to be shown, presented, and how it's going to be framed even, right? So, and now Lammy just says most people don't have a jury now, that you can't have one. So what's that reduced it to, that it's not even been there, And actually, if it says, according to the law of the land or by peers, who decides that or? That's the thing. And I think that or was meant to be that or there's a legal argument to decide whether that or is the division between summary or indictment, Was that or that if it's summary only, it doesn't require peers because you haven't been indicted, right? What was that the purpose of that? Because if you didn't have that word or there, and it was your peers, then all prosecutions would have to have a jury. And if it didn't have the word peers and it just had according to the law of the land, then you didn't have them anyway, right? I mean, is that word meant to be there to separate between summary and indictment? And if it is, then, you know, you're meant to have them, the jury. They've already reduced the functions of the jury dramatically down to just being sat there and, like, you know, it's almost like they're put in front of a very controlled kind of like presentation, whereas they were actually actively looking at the documents and passing them to each other, and, you know, and sometimes they were directing more evidence to be called. And in this thing, when you can have a view, right? The jury would probably decide, if the jury are the ones who are looking at the evidence and see if there's enough evidence to convict with, and then they approve it, surely if they're deciding on if there's enough evidence or not, surely the jury should decide if they want a view or not, or if they need a view, you know. And nowadays, when the newspaper's already reported on it before someone's been convicted, how do you know that? Because, like, you know, people find out about the case and get to the house and go and alter the evidence or sneak into the house and move the things around, which is why police put tape around. But these cases weren't supposed to be reported to the newspaper, really, until someone's been convicted. I know the newspapers are allowed to be in the gallery and they can watch and they can listen to proceedings when they take on and report on what was said as much as the public can be in there. But that's just the public and local community. I don't, you know, and that's the trial. The grand jury is supposed to check if there is enough evidence, right, for the trial, right? And then when you have the trial, that's when the newspapers appear, right? But without the trial, I mean, I know some trials go on and on and on, but then sometimes they can put newspaper press blankets on so the press aren't allowed to report on it or whatever. But it shouldn't be in the newspapers, you know. Sometimes now they're reporting crimes before the trial, like, you know, 5 people were arrested on suspicion of this, right? And okay, but, you know, sometimes it doesn't tell you where it was, but sometimes it's easy to know or find out where it was from that, and then people can end up going to the scene of the crime and changing things, right? And maybe the police haven't got any tape off or cordoned it off or anything like that. You know, it's quite concerning, really. This is like all the laws being flaunted, you know, for the elections as well, you know, not supposed to show the candidate in a capacity where it can affect their popularity for elections, right? So, and they're actually, you know, there's a lot of, you know, Nigel Farage with his Talking Pints programme clearly led up to his election and affected his popularity. He ended up winning from his Talking Pints programme on GB News. So this is what it says. This is what Google says, and I know Google's not always right, but I thought I'd just get the brief summary. It says the confirmation of the Charters 1297, or Confirmatio Cartiamen, was a crucial 13th century statute issued by King Edward I to confirm the Magna Carta 1225 and the Charter of the Forest. But that's not true. It confirms the Charter of Liberties 1100, but they're saying Magna Carta 1225. Magna Carta was 1215, and then the proper Magna Carta was put into law 1275, so this is dubious. It mandated that these documents be held as common law throughout England, ensuring that any judgment contradicting them would be void. Well, actually, that's not true. It actually is meant to say that those charters shall be kept in effect and not be changed or modified, right? It says 1297 confirmation. What was 1225? Hold on a minute. Definitely 1297. It's saying that it was made into proper law in 1297. So I'm asking it, what is Magna Carta 1297 in relation to the 1215 and 1225 Magna Cartas? The 1297 Magna Carta is the final definitive version of the 1215 and 1225 charters, which was enacted into English statute law by Edward I in exchange for taxes, unlike the 1215 original annulled, or the 1225 reissued. The 1297 version is the official text that established the charter as binding law, ensuring its lasting legal authority. So 1215 one was annulled, right? They reissued it in 1225, and then in 1297 it becomes actually binding legislation, which is the version they've got on the legislation.com website. So going back to the confirmation of the charters then, 1297. So now we know what we're talking about when we're reading it. So, crucial 13th century statute issued by King Edward I to confirm the Magna Carta, the 1225. That's the reissued one. The 1215 one was repealed. It was reissued in 1225, but it wasn't put into actual legislation until later on. And the Charter of the Forest, it mandated that these documents to be held and not changed. But I think that it's meant to be the Charter of the Liberties. It doesn't actually say the Magna Carta, it says the Charter of the Liberties. So I don't think this is necessarily right. So now we've got to ask it. This is what Howard Crowes was doing, challenging the AI, right? The confirmation of the charters, 1297. So now we ask it, does the confirmation of the charters 1297 confirm the Charter of Liberties 1100? It's saying it doesn't. It's saying no, the confirmation of the Charter 1297, often known as Confirmation Cartman, did not directly confirm the Charter of Liberties 1100. I think it did. So it's actually disagreeing with me. According to this is saying that if it does confirm the Magna Carta and it has to be kept in every point, then it shouldn't have been repealed. It shouldn't have actually been changed or modified, right? The confirmation was specifically directed at reissuing. It was directed at reissuing and confirming the actual Magna Carta, but the Magna Carta itself actually upholds the Great Charter of Liberties and the Forest as well, right? The Magna Carta upholds the Charter of the Liberties, and it cannot be changed or adjusted on the Charter of the Forest. And then the confirmation of the charters is meant to uphold the whole thing. They were issued around the same time, so there's definitely a relationship and connection between Magna Carta becoming law and then this 1297 confirmation of the charters as well, or else they wouldn't be done at the same time, would they? It'd be a bit obvious. But the fact is that, the Charter of the Forest has been changed when it said that it cannot, and it has. So the government have done some treasonous activities there for sure, yet how come they never not getting called out on it? How can we be in a legal situation, right, where Shabana Mahmood, right, put a prescribed group, like, Palestine group, into a schedule to prescribe it, which is making legislation, which she's got the power to do. And in making that legislation, because of EU law, she can get called out by a court for, violating a convention, right? Even though she's not a public authority when she did that, she was not acting as a public authority, that's for sure. She was making law and legislation, which is parliamentary process, which she's got the power to do, right? And now you can get challenged in the court and called out very easily by some protesters, right? On convention, right? When we can't seem to easily call out, the government at the time for changing the confirmation of the charters by changing the Charter of the Forest, which must be kept in all points. It says it must be kept in all points and in perpetuality and all this, right? And the Magna Carta keeps the Charter of the Liberties in the Forest, etc. And the confirmation of the Charters are supposed to keep Magna Carta. But this is the thing, right? Now, the problem with Dadid Lammy in this jury trial thing is this, right? Although past governments have changed and repealed some of these Magna Carta clauses, which they're not supposed to be able to do at all, which they can't change them or modify them, right? The clause which has the right to the jury trial in it, which is a constitutional law, hasn't actually been repealed or changed, right? This is the thing. It hasn't actually been changed. So is Dadid Lammy himself acting actually against the provision which is still in effect? That's the question. And how is it possible not to be able to get him called out for violating a convention, right? Because this is not European law convention rights. It's just, something and nothing. It's like the constitutional law of England, which is meant to be obeyed and kept in effect to every point, right? And it hasn't been because the Charter of the Forest has been repealed or changed, right? It says that it can't be, right? And actually, that was done before... You know, that previous thing that I showed you, which only applies to Northern Ireland now, and if anyone, affects or violates or changes the Constitution, it's an offence or crime. They didn't change that until 2009, 2010, right? So, was Queen Elizabeth, was the government, not Queen Elizabeth, because she just gives royal assent to it, right? Who was behind it? Well, did that government, because that law was still in effect at the time, right? For England. So, because that law was still in effect at the time in England, did they violate, what was that, a major serious crime? I can't see how, right, you can have a government repeal and do something which explicitly in law it says that it must be kept in all points, it cannot be changed or repealed, and etc., right, and it must last for perpetuality, right? How can it be that the unconstitutional law of the country, which at the time, when they did all these things in 1948 and 1967, cannot be done by your own law, yet in 1998, we joined this little EU thing, right, and this little EU club, and you say, oh yeah, we've got these EU convention rights, what's put into your law in 1998, and then the next thing, the court suddenly can get involved with Parliament and criticise Parliament and call Parliament out, and even like protesters, calling Parliament out and having judicial reviews and all kinds of things, which I don't know how they can do that, because if they can do that, then the Ombudsman can do that, and the Ombudsman never does that, right? Since when does the Ombudsman start calling out MPs and ministers for violating convention rights? Surely it would save you the money of a judicial review, which normally costs you 10 to 20 grand, right? So why wouldn't you be getting the Ombudsman to do that, right? Because we're paying for the Ombudsman, right? So why would we be paying for judicial reviews? And I don't even know if that woman paid for a judicial review or not, but when you get them for councils, I know that it can be expensive, right? So I don't know anything about that woman from that, Palestine group, or who paid for it, or how much it cost, or if it cost her anything or not, because, I've never been able to get them for free of charge, and a lot of other people complain about them being expensive, right? Why can't you complain to the Ombudsman, get your MP to sign it off, and, get Shabana Mahmood against a convention, right? If a court can do it, then the Ombudsman can do it, right? This is the thing. But apparently the Ombudsman can't do it because it's all MPs and they're privileged. They need to get their facts right. And, so we need to understand when it comes to Dadid Lammy, right, with these jury trials, right, that whatever the law is about the jury trials in constitutional law, it's still in force because they haven't repealed it. And this is the wording of it. But we know that in 1934 or around that time, they scrapped these grand juries, which actually were active. They did something, but then it had just got to the point where they just got them, like, they're literally wheeling them in to say, sign this off, to say that there's enough evidence to charge or whatever. And then they just have like these normal juries, which just like they're called in at random and they swear their oath and they sit there and they do what they're told, and then they just like listen to whatever the Crown prosecutor pulls out of his pocket, right? Like, 3 sherbet lemons and a fucking, fizzy roll or whatever, right? Not like, hey, just a minute, we're the grand jury. We get to look through all this evidence and check to see if there's enough evidence to prove a conviction, and we can even, ask for more evidence or like go for review. It's like, oh, if we decide there's enough evidence, we need to see the scene of the crime, right? And all this type of thing, right? Not just like, sit there and shut up, right? And listen. Like, this is the thing. So, it doesn't even show you the actual original. There's so many websites about this. There are like, when it comes to Magna Carta, there are lots of weird groups and societies about it as well. And I don't know how they haven't managed to stop Dadid Lammy either so far. Right, so this is the online Library of Liberty, and this is like one of the Magna Carta official translations, and it's meant to be the William Sharp Mackenzie translation, right? The William Mark Kenzie translation. So, no free man shall be taken and imprisoned or disintered or exiled or in any way destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers and by the law of the land. Why has it got that brackets and? It says, except by the lawful judgment of his peers or by the law of the land. Why is it in brackets and now? If it's by his peers and by the law of the land, so you apply the law with your peers deciding on it, right? So that's not going to be the case if Lammy takes with the jury trials, is it? I'm just going to take a screenshot of this. I don't know how could this government have managed to get it so that, if it's against EU law convention, right, you can get like Shabana Mahmood in the court, but when Dadid Lammy's doing this jury thing, you can't get him in the court, right? How could you get your own government in the court for violating EU laws, but you can't get your own government in the court for violating the law of the country that says the government can't violate it? See, we've got this little bit here. Under Magna Carta, the king cannot imprison a free man without being convicted by a trial of his peers. Clause 39 became the foundation of the idea that freemen could not be imprisoned without first being guilty by a trial by his peers. This later became the idea behind the principle of trial by jury. But it says and here. Like, that's important, because if it is and, then Lammy can't do what he's doing, but yet he's done it. And even George Galloway, people have been talking about this. Thoughts on clause 39? Guaranteeing the right of a free man to trial by his peers before he could be lawfully imprisoned is one of the most famous clauses in Magna Carta, along with the right to habeas corpus, that the accused must be presented to the court in person for charges to be read and the trial to begin. It became the foundation stone of English and the American court procedure and a symbol of the traditional rights of Englishmen. Some radical legal theorists like Lysander Spooner believe that not only do the jury in a trial have the right to pronounce on the guilt or innocence of the accused, but also could rule on the very justice of which laws under which the defendant was accused, thus making the trial by jury into a quite radical tool. In which the defendant was accused. But also could rule on the very justice of which laws under which... You see, because when you interpret that, it can mean like because if you're having your peers, right? If you've got a trial by your peers and it's instead of the law of the land, that means that you're not actually applying the law of the land, you're only applying your peers' judgment, right? You're only applying your peers' judgment, and then you don't have to have the law of the land applied, right? That's one interpretation. Now, if they're taking that away from you, then it can only be by the law of the land and not by jury at all. I think this is this dispute that they've got with Lammy, because there's a lot of juries acquitting people now, and the government don't like it that they're making them put all these laws through. But then suddenly you can have a jury trial who says that the law doesn't have to apply, or they don't want to apply the law, or believe, like in Ian Bray's case. Basically, the case of Ian Bray is a classic example. And the government actually really don't want that to happen. But if that gives you a constitutional right to have that, a possibility of that happening, then they're definitely taking the constitutional right away from you. I would, this whole David Lammy thing, right? I think that it's actually not about Lammy and about his stupid acts and actions. I think it's about the fact of what the jury is meant to be actively involved in, look at the evidence, and they've reduced it so they just sat there and get dictated to by the Crown Prosecutor, and they're controlling everything. It's a controlled environment now. And they're not actually, people chosen out of the community who want to assess and look at if these charges are valid or not, and can't even go for review or call for evidence. And they're actually active judicial persons, like the judge or magistrate is in a petty session, but at a more serious level, because all of them, the petty sessions magistrates, the lower level magistrates, are meant to be voluntary. They volunteer. They're not going to get paid. They're like volunteer. They're just like, people who are passionate about justice, right? And they're not even all of them legally qualified barristers. That's why they have the legal advisor. So they don't even really know the law. Now, that's meant to be for summary. Remember, the councillors, the local councillors, used to be on a rota, like with the aldermen, for crime, right? Like in the City of London Corporation, like in the William Penn trial, right? But they even had a jury there. The William Penn trial, they've got the aldermen with the crime committee, there's a number of them, with a jury as well. And not just, because that was a more serious offence, right? I don't know whether William Penn's trial had been looked at by a grand jury to check out if the charges were valid enough to bring anyway, because in London, in the London Corporation, I don't know if they had grand juries, but they had them in the countryside. They definitely had them in the countryside if you didn't have, like, a corporation or something. If you were just like, if you just had like the judges' circuits coming around, then it wasn't like a corporation, right? I think what this whole argument is about, right, when it comes to David Lammy and the jury trials, it's about really the fact that, have the government broken the law? And have the government broken the law in the past? Have the government broken the law with the Charter of the Forests, right? And that's ironic because it's to do with the king's rights and hunting in the forests and things like that. In modernisation, maybe, people, don't think that those laws should be enforced because they're all arcane and archaic laws, right? You'd have thought people in Northern Ireland would be more bothered about that because, the King's lands and, it being like, the whole sort of like Northern Ireland versus the monarchy sort of thing, and like forests and lands in Northern Ireland, they would like be opposed to the Magna Carta clauses which have been repealed. But the Northern Ireland law is the law that says that, the Constitution has to be upheld in the charters, right? Which apparently, Lammy seems to be breaking that at the moment, depending on what your interpretation is. I mean, does Lammy even think that there is a right to a jury trial at all? Right? If it's by the law of the land or by a jury trial, then there never was a right to one, and then they should have had one. If that's what it meant, then why did they have one in the first place, right? Wouldn't they have liked to have just had, send some justices from the king to go and decide, who's guilty or not? Why did they even have them? It has got to mean more, it's, have you got a right to them or you haven't, right? And it seems that Lammy doesn't think that the general public have got a right to them. And they don't even have them in higher courts than that. We don't know much about juries being in the High Court. Well, I've never heard of any cases where they have juries in the High Court. I haven't seen any juries in the High Court. I know it's more rare for criminal trials to go to the High Court. I know Angela Ditchfield. Okay, let's take Angela Ditchfield's case, because that just popped into my head, and that's a good, actually, example. Angela Ditchfield was acquitted. Then the Crown Prosecution Service. She was acquitted at the Petty Sessions at the Magistrates Court. It was a political action, actually. She got acquitted just on her own personal defence. She never went to the Crown Court. She never had a trial by jury. The Max Hill, the Director of Public Prosecutions, took it to the High Court. They skipped the Magistrates Court. They skipped the jury trial, and she got convicted. And I don't think they definitely didn't call a jury into the High Court, right? I don't think. And I've read the paper for that, and I definitely don't think I saw anything about a jury being in there. This is the type of thing that Lammy is moving for, right? And that's what happens even when you've been acquitted, right? When you've been acquitted, petty sessions by a magistrate, then the Crown prosecutors are going after people. I don't think they would have been able to do that if it had been a jury who acquitted her, because it was a public interest. But, if the Crown Prosecution Service are, getting rid of these jury trials and effectively, that's the type of thing that, getting acquitted by a High Court. How did that High Court not recognise that Angela Ditchfield was, engaging in a political activity and that, she was using the control of advertisements with the Bill of Rights, and it was Extinction Rebellion representation in public presentation, right? How could the court fail to do that? And that's the standard that Lammy's wanting to aim for now. Whereas, with Ian Bray, the jury acquitted and the CPS couldn't sort of really go against that because it was the people, the public. And I think that's definitely highlights the issues here. But, these grand juries have already been reduced anyway. They don't actively look for the documents. The grand juries were meant to know the constitutional rights and law. At the moment, the juries, when they get them in, they aren't told any law, and they're not allowed to go and research any law or look into it, supposedly. But that's wrong, because they're meant to know the rights and liberties of the subjects. There are oaths from jurats, which aren't grand jury, but they're like the aldermen. They're the sort of like pre-prototype aldermen, right? But out in the countryside, when there's no corporation, when they don't necessarily have a corporation or whatever. The jurats are very strange. I think they stayed in service permanently. The jurats took an oath, and they had to uphold the rights and liberties of the subjects, right? So they have to know what they are. So I'm pretty sure that when the grand jury was sworn in, well, let's get some oaths. We'll look at some oaths for the grand jury. If the grand jury have to have sworn an oath similar to what those jurats have sworn, and I've got the oath, I've got it, I obtained it from Kent Archives, right? If the jurats had to swear a similar oath and they had to know the rights and liberties of the subjects and uphold them, and not just like according to justice, only like what's presented, then those jurats wouldn't have been just looking at the evidence which was submitted and deciding if there's enough evidence, and also going for review, which meant they could get more evidence or request more evidence, or to go see somewhere. They could control the request of evidence or not, and so forth. And it's now just been reduced to go sit there in a box and just sit there and we'll tell you what happened, right? Let's look for the let's see what oaths we can find for the grand jury, not just the jurats, because I know the jurats are different to the grand jury, because the grand jury is only called or when the circuit comes around, whereas I think the jurats were permanent. And I've got the oath for the alderman in my book. Hold on a minute, let me pause this. So the common councillor oath had to be signed. It says, I do solemnly, sincerely and truly declare that I will faithfully perform the duties of the office of a common councilman of the City of London. It's not an oath of supremacy. I've actually taken oath of supremacy because, oath of supremacy is just to the king, but also to God. There isn't a religious or there isn't actually any. It's not an oath of supremacy, the oath of a common councillor. I want to see if they've got the judicial oaths in this book. This is the City of London Corporation. I don't know if they've got the mayor's oath or the alderman's oath. I'm not sure. So it says the earliest recorded aldermanic oath with specific wording from 1200 is scarce. The earliest recorded aldermanic oath, 13th to 14th century. While specific wording from 1200 is scarce, the early oath of the mayor and alderman is recorded in the city's letterbooks and later in the Liber Albius, compiled 1419. The oath required them to keep the city's secrets, not to disclose counsel or conversations they had in the court of aldermen, particularly regarding the city's private affairs, uphold the king's peace, to maintain the peace in the respective wards, to give impartial justice, to administer justice to both rich and poor without favour or hatred. Well, that's what's happening with our privileges in Parliament. They're not upholding our privileges and rights to petition and protecting us, whether we're rich or poor. And private bills were usually rich people, and public petitions, grievances were usually poor people, right? Like all these protesters, and they don't even have any private bills anymore. They're only 1 to 2 a year, and they put a lot of the permissions for a lot of the things that private bills were for. They've now put into acts of law to deal with it. So you apply and object or oppose through an act of law and a procedure made in an act of law, not directly to Parliament. That's what that Pamela Thompson, the parliamentary agent woman, told me. She says that's why there's a lot less private bills going through, because if you want to object to railways or have an issue with railways in your area, there is particular processes to be applied for through the act of law created, so you don't do it anymore through a private bill of action. But we're meant to be able to use private bills because we want to oppose the council, right? And also you can be creative in doing it as well. But I think that's for a direct opposition to a railway, or if you're criticising it or have comments on it, right? Not if you want to make your own special act of law to specifically intervene in a very custom way, in a very creative and custom way. But we're not, whether rich or poor, we're not having the MPs aren't upholding our rights. I don't think MPs even know their own proper rights. Mike Amesbury, Dan Norris and Patrick Spence. To protect the franchise and customs of the City of London, maintain the liberties, but that also maintaining the liberties and franchise and customs also means to keep in effect Magna Carta and follow Magna Carta. I don't know whether or not when they had it in the oath to uphold the customs and liberties, I don't know whether or not Dadid Lammy would have been able to make changes to certain law. Hold on a minute. Why didn't it include the oath in here when it tells you this? I wish it had just Coronation Oath Act 1688. This act created a new oath wherein the monarch promised to solemnly promise to swear and govern the people of this kingdom according to the statutes in Parliament agreed on and the laws and customs of the same. Passed shortly after the Glorious Revolution. Hold on a minute. A pledge signed by many to maintain the laws and liberties of England, Scotland and Ireland, and to protect the Prince of Orange, ensuring security against a return to popery and arbitrary government. 1698 changes direction and returned the previous oath, which had demanded obedience based on the laws and customs granted by the Kings of England, shifting the basis of the authority to parliamentary law. These acts confirmed that the monarch's power was not absolute. So the previous oaths were more actually to the absolute of the monarchy rather than to the constitution. Right, this is what I wanted to find after all that. I asked, show me examples of the full complete oaths of a grand jury in England as well as you can find. So I hate using AI as well, but it seems convenient. Historically, the grand jury in England was known as the Grand Inquest or the Grand Jury of Presentment. Its oath required jurors to diligently inquire into crimes, present the truth, and keep the King's counsel, their own and their fellows' secrets. Below are full historical attested examples of the oath ranging from the 17th century to as late as the 19th century before its abolition in 1933. I told you it was 1933. I was right about that. So, but now that's what the Crown Prosecution Service do. The Crown Prosecution Service are diligently looking through facts and information that the police provide and making a decision on whether to prosecute, right? Just a minute. I've just had the most astounding revelation ever that I've had, I think, for this whole justice thing, right? The grand jury took an oath and was sworn in and was supposed to be chosen only when the courts came around from the community. They're the jury, and they're the ones who check and look at the documents and see if there's enough evidence, right? Obviously, the police have to go out and get evidence, like the police are meant to be the brute squad, right? But obviously the police are going to be intelligent enough, you know, to go and get fingerprints and forensics and all that. I'm not knocking that, right? And they like question people and get statements and they keep people detained, but the grand jury were meant to be the ones who actually, you know, judgment by your peers, right? Not just sat in a box, right? And then a guy walks out, a lawyer, a solicitor on behalf of the prosecution, and a lawyer and a solicitor on behalf of the defence, right, and make a case, right? The grand jury were meant to check to see if the evidence was valid or if there was enough evidence to prosecute, and supposed to kind of like be the proper weighing scales, the impartial body, right? And then you've got the judge, right? But in 1933, by the time they got to 1933, they ended up saying that they were just there, like, sort of like ceremonially to like sign it off, like, you know, the charges, which is wrong. And now, you see, the Crown Prosecution Service weren't around until 1985, right? Which is when they repealed the Tumultuous Petitioning Act, and you got a grand jury could approve that, right? And then you officially were petitioning Parliament, right? You officially were, you got it signed off, right? It's like if you actually have a judicial review now, it's like you're actually really doing it. You know, it's not you saying you're doing it. There's going to be proceedings, right? What actually? With this Crown Prosecution Service, they are the ones who are looking at evidence and documents and making decisions and calling the police to get more evidence. That's actually what the grand jury are meant to do. But yet these people are in full-time employment. They're actually an organisation, a body, and they're actually even under, like, Solicitor General. You know, like the Attorney General. You know, the Attorney General is in charge of all solicitors, whether they're not Crown prosecutors or not, just like all lawyers in the whole country, right? But then you get the SRA, Solicitors Regulation Authority, bar standards, but the Crown Prosecution Service, they've got a chief Crown Prosecutor, almost like a chief police officer, right? You're not meant to have, like, under Magna Carta, when you're getting judged by your peers, you're not meant to have, like, a chief, well, I don't know if I think they might have a representative, like, choose someone who's the spokesperson of the jury. They're meant to be like your peers and selected from the public at random when the courts come around, except there's jurats in Kent who served for a lifetime, but they were like when it was all figured into the council, because the council, remember, had the aldermen, the mayor, the common councillors who don't have a judicial oath, under the aldermen, and then you've got your jurats. I don't know if the jurats were like they did serve for life, but if you could say, well, but they're not the prosecutor though. If the jurats are going to be there in any capacity, like somewhere between like the alderman and your jury, we'll check up in a minute. We'll look at it in a minute, right? Let's take the William Penn trial, because you've got the mayor, Sam Sterling, whatever. You got the mayor there. You got the aldermen, like, a handful of aldermen around the mayor, right? But they're not the jurats. And then you've got the sheriff sat there as well. And then you've got the jury at the side, who are meant to be, selected from random or whatever, however they do it in London, whether it's grand jury or normal jury or not. But they said that they weren't guilty, right, in the William Penn trial. But you had William Penn and William Prynne appearing there and answering. I don't think there's a solicitor named on there. In that trial, I don't think there's a solicitor speaking. They're just like answering in front of the assembly. Maybe he didn't get a solicitor, maybe he's self-represented, I don't know. But you did get solicitors when you were representing in Parliament, You could get a solicitor to represent you at the Bar of Parliament, right? And I think the Attorney General and Solicitor General represent Parliament. Unless you've had your rights being violated by the other courts, and then it's a breach of privilege of Parliament, and they're meant to... you're meant to have the Attorney General in the 1936 Public Order Act, right, is meant to check prosecutions to see if people have got political objects, right? That means that he's meant to be checking to see if it's lawful or not for them to be prosecuted, because there might be parliamentary privilege, right? That's like Solicitor General and Attorney General acting when it's breach of privilege, right? Anyway, so what I think they've done is, by 1933, they've managed to reduce the powers of the grand jury, and then they got rid of the grand juries and just have these normal juries in criminal cases where they just sit there. And then, the prosecution presents a case and the jury just listen to the evidence, right? And now they've got it where, rather than just the police used to instruct solicitors. All solicitors were regulated, right? And you had the Attorney General and so forth. But as far as what I've read, the police, the police aren't barristers. But Patrick, look, you got Patrick... what's his last name? Not Patrick Spence. The barrister who won the Lord Hanningfield case, right? Patrick Gibbs, right? KC. Patrick Gibbs KC is a barrister. Anyone can go to him and employ him, right? The Crown Prosecution Service are all solicitors, and they have their own barristers, right? But to prosecute Lord Hanningfield, the CPS hired Patrick Gibbs KC, right, to go in. He was the prosecuting person, the prosecutor, right? Now, he is the prosecutor. Now, back in the, 1800s or 1700s or whatever, the police, the sheriffs, if they're prosecuting on behalf of the state or the government or whatever, someone's in court, they appoint barristers, right? Because the police are police officers. They're like, the mob, right? They're like the hands-on, the handcuffs and batons and, forensics and so forth. They're not barristers. The police have got a legal team and a legal unit who are more experienced legal officers. But when you go into the police can do their own prosecutions. The police can still do their own prosecutions, right? But they paid barristers. So like, oh, I'm a barrister working regularly. The police hire me. I do prosecutions for the police, right? Here's the casework. We've got the evidence. We submitted it to the court. You go turn up and you've got to get this person convicted to prove that they committed the crime. Here are the fingerprints and the evidence, right? You do it, right? So the prosecutor turns up on behalf of the police or, the state, and then the defendant can defend themselves or pay their own solicitor or barrister, right? But what they've got doing now is this Crown Prosecution Service, who the police now pass cases onto when it's a crime, not just like, automatic fine and pay for it, or, confess and, pay the fine or whatever, right? They are sorting evidence, even directing or instructing the police to get more evidence, and that's meant to be what the grand jury do. But they may be your peers, and they may be selected from the public, and they're not meant to be under like some kind of chief Crown Prosecutor ranking officer with a Attorney General. Because if you're a jury selected from the public at random from the electoral register, whether it's a grand jury or not, or a normal jury, and you swear an oath and take it, the Attorney General is not your master. The Chief Crown Prosecutor is not your ranking officer. The Chief fucking Police Officer is not your chief, right? You are selected at random from the electoral register of the public and take an oath to look at evidence to see if, there's enough to prosecute or not. Now, if you say, well, the CPS are legally trained men and know the law, well, this is the thing. This is why I'm getting my finger on the button. These oaths, jurats and things like that, and aldermen and so forth, the men who uphold the rights and liberties of the people. So the men who know people's fundamental rights. They're not many who know criminal law, all of the criminal law, because a magistrate now is not required to be a qualified lawyer. A magistrate now is not qualified to be a judge. He's not meant to be King's Counsel or have to be a silk, or not meant to be. They don't have to be a King's Counsel. They don't have to be a silk. They don't have to be a qualified lawyer. They just have to be a volunteer. Someone who's volunteered, who's concerned about crime, and that's an interesting job they want to do, and they volunteer to do it, and they get familiar with it, and they've got a legal advisor there to advise them, right? But I'm pretty sure that the jurors, when they're sworn in the jurat's oath, they had to know the liberties and franchises, which means they've got to know the Bill of Rights. When you get arrested, when a police officer arrests you, he reads you your rights. You have the right to remain silent. Anything you say cannot be ruled against you in a court of law. How do you need to know that? Why do you need to know those rights? Read him his rights. Why does the police officer need to read you your rights? What is the point? Why doesn't he just say you're under arrest, put the handcuffs on, and that's it? I don't care. Why does he have to read you your rights? It's a little thing that he reads out. Because there's something you're meant to know. Like, he's informing you that you can be quiet and shut up. But, if you do say anything, it's going to be used, right? Has he got a right to, do they have a legal obligation to inform you of your political rights? Do they have a legal obligation to inform you of your medical rights? They've got a doctor in there. They've got a doctor at the police station, so you must have some medical rights, or they wouldn't have a doctor in there, right? And they've got a priest who goes around sometimes at the police stations, they've got a chaplain. Although, I think when the police have got their own chaplain, it's for the police, but if you want one, I think that you can request one and have one. You've got the right to have a chaplain or whatever. I think that you have an independent one. Anyway, We'll check those jurats. I'm going to find out more about those jurats in a minute. I can type that in now. Let's go through these oaths. You shall diligently inquire. This is the jury oath. This form was commonly used in the courts of quarter sessions and assizes. You shall diligently inquire and true presentment make of all such matters and things as shall be given you in charge or shall otherwise come to your knowledge touching this present service. Well, everything coming to their knowledge. But if everything that comes to their knowledge, what happens if there's some law that comes to their knowledge, a legal point, but apparently jurors aren't allowed to search it when they go home? They're not allowed to look into the law. They've only got to be told what the prosecutor tells them or what gets read out in court. But in here, they can inquire into it. The Crown Prosecution Service are inquiring into the facts, matters. They're the ones who are supposed to go all the law books at the CPS office, right, and read all the law and so forth. But I do know that the grand jury were only supposed to look at the evidence. And I think there's something in that, you know, it says that they're only supposed to look at the evidence to see if there's enough evidence to prosecute, and they're not supposed to examine the law. But there is a core fundamental set of legal things that they're meant to know, which is like why that plaque is on the wall. Because, like, you know, at the Old Bailey, they've got the plaque on the wall from the William Penn trial, you know, that says, you know, juries have got a right, you know, to come to their own verdict according to their conscience. That's legal advice, right? It's on a plaque on the wall at the court, and it's legal advice, and the juror is allowed to know it. Why is that? Because they're meant to know the fundamental rights and so forth, but they're not allowed to go. If they weren't allowed to research or look at the law, jurors, that wouldn't be on the plaque at the Old Bailey, or else they wouldn't be allowed to read it, right? And there's something in this, and I think the Crown prosecutors are all completely and totally aligned to their own organisation. They scrapped the Tumultuous Petitioning Act when the CPS was formed, so very few, if not any, Crown prosecutors have been prosecuted for, you know, breach of privilege, and those rules in the back of the standing orders with the fees for getting people called in for breach of privilege, and for sure in the journals, right, there were people called in for breach of privilege, plaintiffs, people bringing cases, Crown prosecutors or lawyers bringing cases, even judges bringing cases against people doing private bills, or against people who are in the newspaper for a private bill, or in the public business. They're in there. They're all the journals. It's in the journals, right? The King's Counsel, your fellows and your own you shall keep secret, right? So that's like, you know, when they're deliberating, they've got to keep their deliberations secret. They're not allowed to talk to anyone about the case. That's still the law. If you go on the Crown Prosecution website, it tells you this. If they breach this, they're actually in contempt of court, right? If they breach it, they're in contempt of court, and someone can report it into a court. You can report a contempt of court into the court officer. And very few people do this. You shall present no person for hatred, malice, or ill will, nor shall you leave any person unpresented for fear, favour, or affection or gain. So they're not like, you can't have political cases in front of the jury, right? Because the public support or oppose political causes and are entitled to, right? This is something the Crown Prosecution Service and Dadid Lammy really need to get their head around this. Like, this is a really big one, right, which I have been hammering at the courts and arguing with them in the CPS through the forms. I must have submitted about 10, 20, many complaints to the CPS in writing, on official record. They say that they're a proper authority and they've got scrutiny panels and so forth. They don't scrutinise anything, right? I've told them, right, and I've told a lot of courts in London, right, when there's a lot of Stop ULEZ cases, right? If it's a political cause to Parliament, right, every single member of the public, whether they've signed that petition or not, can support or oppose it, because it's put in the newspaper, right? It's required to be published. If you've got a private bill to Parliament, right, for a freaking railway, right, it has to go in the newspaper under the premise that every person in London is informed, right? Because that's the purpose and objective of putting it in the newspaper, right? The purpose and objective of it being required to be published in the newspaper, if it's a London railway, right, if it's a private bill, and I know that they've changed it over to legislative control now for railway oppositions, but this is like, we need to, like, okay, private bill on anything, right? All those people in that local area have to be informed. It's not like, oh, I'll put it in the newspaper so one or two people know about it and then a few of them might object, right? Its legal objective in law is to ensure that all persons are informed that a public bill is being pursued and that they've got a right to object to it, right, and make a legal representation. So that means that they're going to have opinion for, against. Now, where do you choose a jury from in London? You select the jury in London from people in London. They don't come from Scotland or Cornwall, right? So how can, if you prosecuting someone who's got a private bill into Parliament, right, for the newspaper advert, right, for libel or whatever, how can they prosecute you in court? And how can you have a jury in there who don't fucking know about it, right? Because they're meant to know about it because it's meant to be in the fucking newspaper, right? So how can they not know about it? So we've stopped you, Les, right? We've stopped you, Les. You know, you've even got Susan Hall and Councillor Simon Forthrop turning up, right? Who traditionally might have even been on the crime committee on the council on the rota, right? Potentially, but common councillors don't. But the aldermen are on the rota. I got it wrong last time. Right? It was just an example, right? You know, he could have been an alderman, right? Could Simon Forthrop, but he's just common councillor. But common councillors went on the crime committee, but because they don't take that oath. But he could have been the alderman, right? For example, but. With this, right, this is the oath of the jurors, right? You shall present no person for hatred, malice, or ill will, nor shall you leave any person unpresented for fear or favour, affection, for gain, reward, or hope thereof. But in all things you shall present the truth, the whole truth, and nothing but the truth, according to your best knowledge. So help you God, right? So you've got to actually. This is not an oath of supremacy either here. The King's counsel, your fellows, and your own you shall keep secret. So that's like on the King's business, which is the deliberations on the case, I think. You shall diligently inquire and true presentment make of all such matters and things that shall be given you in charge of. So you should be checking to see if that, you know, if people have got a case to Parliament, right? You should be checking to see that they have, or if you know they've been holding some signs up. They offended the Mayor of London. Well, what were the signs about? You know, they got to inquire into it. They inquire into it. Not the CPS who are already supposed to inquire into it and present the case, right? The jurors who were like selected from the public at random and sworn in an oath. What they've done now, I realise, is they've transferred all of this peers, judged by your peers. They've transferred it all over to CPS, who they're not my peers. They're full-time workers in crime. And they're prosecutors. Now, are they prosecutors or not? Are they barristers? You know, as Patrick Gibbs. If they're prosecutors, why have they got Patrick Gibbs in as experienced barrister? Because they aren't experienced enough to do it, right? Come to your knowledge, touching otherwise, come to your. It says all things shall be given you in charge, or shall otherwise come to your knowledge. You know, presentments from the sheriffs, like, you know, come to your charge, right? But otherwise, you know, come to your knowledge. You can actually inquire into it yourself. So they've made it so they're not allowed. They're telling them they're not allowed to go and research the law. The thing is that they're not. I don't think the jury are supposed to decide on. The grand jury were only meant to examine the evidence itself, if there's enough evidence. They weren't supposed to look into the laws and decide what was legal or not legal. But they could seek more evidence, and they were supposed to know some of the laws. The truth, the whole truth, and but the truth according to your best knowledge. The oath as recorded in the 17th century, 17th to 18th century, you shall swear that you will well and truly inquire and truly presentment make for all such articles, matters, and things shall be given you in charge or otherwise given you in information. Well, it says otherwise. There must be some other way to get information. Is it can't in legislation.gov to be given to them? This is the thing. If like you're not allowed to speak to anyone about the law outside of the court or go read any books or anything, like the books could be by like Tom, Dick or Harry. They could be from anyone. But legislation.gov is the law. Like, are they allowed to examine the rules? Were they allowed to examine the rules of Parliament? Because remember, right, that Bill of Exemption in the Statute of Westminster II, right? That Bill of Exemption. The plaintiff could disagree with the judge on the law and say, I want the king to look at it on the rules, right? Go look at it, right? But what the legal advisor's there for now is to check up on the law, right? I'm sure the jury now can say to the legal advisor, oh, actually, can you just check up on this law for me, right? Or whatever. If the Crown Prosecutor says this is the law, what if the juror doesn't believe him? What if the juror thinks the Crown Prosecutor's lying? Like, oh, you ain't got any rights or privileges, right? Yeah, and if the juror is allowed to ask the legal advisor what the law is, then the juror should have the right to look at legislation.gov.uk, because that is effectively the same as the legal advisor's computer terminal, right? Because remember, if you go back to the 1800s or 1700s, it might not be the truth. This is why the government are trying to get rid of misinformation. The government are trying to get rid of misinformation on the internet, right? Because there might be a law book that's wrong or incorrect. Like Sir Edward Coke got called out on his law books, and William Prynne was calling him out and correcting him on certain things, right? But they weren't the actual rules of Parliament themselves. They were just books, right? And I think that should be the basis of what the jurors can and can't look at, right? And a lot of the time the CPS leave things out or omit things that should come to the jury's attention or that they should know, right? The King's Majesties or Queen's Counsel, your fellows and your own, you shall well and truly keep secret. I think that's the fellow jurors. You shall present nothing for malice, for envy, neither shall you leave anything unpresented. For love, fear, favour, affection, or hope of reward. Right. That hope of reward. Look, right. If someone's wanting the government to do something, right, build you a new park, right? Look, if someone puts a private bill in for a new park in London, which is private, and that's your best friend who's doing it, right? Lots of people might be friends with him. The jurors might be friends with him. Look, if you put a public bill in Parliament, like for extending Finsbury Park, right, or something like that, right? And if you get use of that park, right, and it might be enjoyable to you to use, right, and you support that bill in Parliament, right, and or you don't want them to make that park, you hate the idea and you want to stop them doing it, right? That's like, and you hate the idea, right? And you want to oppose it, and it's been in the newspaper, and anyone in London can oppose the extension of Finsbury Park because, it might take down your best coffee shop or whatever, right? Everyone in London is meant to know that, right? Now, if there's loads of protesters like Kingsley Hamilton or whatever, and they've been protesting against that bill or a public bill, and they get prosecuted and end up in fucking court, right? They're not meant to have a juror from the whole of London who has an opinion for or against that, and, they're all meant to know about it officially. And they're not even going to have that case in the court because it's a case to Parliament, and everyone would know it was a case to Parliament if it's been in the fucking newspaper, right? So this is the thing that you can't reason with the Crown Prosecution Service about this. They're not interested. They don't care. You can send it in the complaints form multiple times, and nothing will happen of it, because they couldn't really care. They're not bothered. Key opponents of the historic oath. Victorian era. So this is the later Victorian era. You shall diligently inquire and true presentment make of all such matters and things as shall be given you in charge as above. And you shall keep secret the King Queen's counsel, your fellows and your own. But what is your own counsel? You shall present no one in hatred and leave anyone presented in fear, affection, hope, reward, but you shall present all things true and as they come to your knowledge according to the best of your understanding, so help you God. It doesn't actually, there's nothing in justice here. There's nothing like to say that they have to act according to law or serve justice. The Assizes of Clarendon were used as early as 1116. The full text of the oath was not typically written out in English. So it seems that the normal jury oath is different to a grand jury, right? So when we got our petitions accepted and validated, it wasn't a normal jury like we've got now. It was that grand jury who looked at various things, right? So historically, the jury oaths in England have evolved from deeply religious pledges focusing on truth-telling and personal knowledge of the facts to secularised promises, focusing on the evidence presented in court. The core requirement established by Normans and refined over centuries was that 12 good and lawful men, jurors, swore to deliver a true verdict, right? Here are the examples. Assize of Clarendon, 12 men swore to make known the truth according to their conscience. So they just had to say what was true according to their conscience towards their own spiritual individual self, right? To make the truth known doesn't actually say that they had to actually, the law had to be applied just to know what the truth was. I mean, the truth of the matter with Ian Bray is that it was a political action, right? And it should really have been privileged to Parliament because Extinction Rebellion was a parliamentary cause. That was the truth. So, I mean, whether or not they actually said that or not, they just found that he wasn't guilty of the offence. So that really still leads to the truth without necessarily all the facts being given, you know. Glanville. Jurors swore to neither utter that which was false nor knowingly conceal the truth. Oaths transition towards evaluating external evidence while maintaining strong religious language, with jurors often swear to declare upon their oath whether the fact of such one of the party says or not. Right, the Victorian era standardised the oath to focus on evidence. All right, so it wasn't standardised until the Victorian period. That actually has just taught me something, because I actually was getting a bit concerned when I was looking into the oaths, like, you know, in the records of the archives, like Kent Archives or, you know, Yorkshire Archives or whichever archives I was looking at. I was finding like some different oaths, and I was like, this is a bit confusing. Like, you know, are there different ones for different positions? They weren't actually absolutely standardised everywhere. So they didn't like have necessarily a national version that everyone said it exactly identically. So you had regional slight variations. So that explains a lot with that Kent oath, the oath from Kent, for those jurats, right? That jurat oath that will serve the mayor and the alderman and so forth. The Victorian era standardised the oath to focus on evidence, notably, I swear by Almighty God that I will well and truly try the issue and give a true verdict according to the evidence. Variations included the true deliverance oath. So it's only quite short oath that try the issue, but then, you know, they aren't the ones trying it. You know, it's the Crown Prosecutor's the one trying it with the court and judge. So they're very uninvolved as it comes to other than just like listening now. I know that I think they sometimes do get to ask questions. Under the Oaths Act 1978, the wording was simplified to allow for and define both religious oaths and secular affirmations. Faithfully try the defendant and give a true verdict according to the evidence. So this is it. The oath they've got now. I swear by Almighty God that I will faithfully try the defendant and give a true verdict according to the evidence. Right. I've just been in to swear documents, affidavits, right, and I literally that is pretty much equal to what I swore. But for those documents, right? So it's not that much different than being sworn in on a jury, swearing in an affidavit or document now. So it says here that jurats in English history were municipal officers similar to aldermen who served as life-elected magistrates in specific towns like the Cinque Ports, distinct from the temporary jury system, while juries originating in the 12th century were selected local citizens who acted as witnesses and later judges of facts. Jurats functioned as permanent executive and judicial officers of a borough's governing body, frequently overseeing both law and administration. Here it says, yes, historically jurats, specifically in the Channel Islands and some medieval English contexts, and the early form of the grand jury, shared similar functions in initiating criminal prosecutions, acting as an accusatory body rather than a trial body. While today a jurat is usually a notary's certification of an oath in the context of medieval English and Channel Islands law, they were sworn officials responsible for identifying crime. Here's how they were similar how they evolved. So, alright, so it's to do with a notary. Today, jurat is usually a notary's certification of an oath. So, like if you're making an oath on a legal documents, it's almost like you're a jurat on that because you swear an oath on it when it's to do with evidence and submitting evidence. In the 12th and 13th centuries, the jury system was not divided into grand, accusing, and petite trial juries. Instead, local juries, often called presenting juries or groups of sworn men, were summoned to report crimes they knew of their area to royal justices. What's the whole point of the sheriff? Just to go do the hands-on work, the rough hands-on work, the sheriff, basically. So almost like the police now with their investigations and the CPS have taken over from what we were doing, although they did have the jurats were kind of like sworn in, but the bailiff, the sheriff and the bailiffs and that were mainly just there to look after the desk, the counter, the gumpty counter and the locking the prisoners up and, you know, going to actually, you know, to arrest and get someone, the hands-on stuff, not the actual investigatory work or looking at the evidence, like this police force which Robert Peel put into place. Maybe we need to, maybe because the police have literally taken over and have got a monopoly on crime and just do what they want and they're all under these military style regime now, the police and the rank and file, it's got its own, it's taking its own direction and, you know, we want these CCTV cameras or we want this or that, you know, like, you know, there's plenty of social media about and mobile phones to get evidence on certain things. The television were just trying to really push for, you know, had CCTV cameras with people looking at it and said, oh, we don't know who these people are. They're trying to sell facial recognition technology, I think, to the public through TV. I actually think now that really the police should just be sent to do the hands-on stuff, you know, to arrest someone. Maybe like, you know, things like forensics and things like that. You need like, you know, to have a proper qualification and to be trained to do that. And, you know, like sectioning off buildings and things like that. When it comes to being back, when it comes to looking at evidence and facts and sorting through them and see if there's enough evidence and directing the evidence, you know, to get more, it's meant to be the grand juries. And the CPS are controlling it all. The CPS are just going to be the prosecutor, the solicitor. I mean, why? I mean, what's the point in Patrick Gibbs, right? What I think now is we've got a serious problem with the police and the whole kind of like, you know, they've become an entity, an organisation, a body with its own interests, right? And we know that with Matt Rowley. You know, Matt Rowley's, you know, lobbying for stuff for the police, like he wants these vehicles or this or that. I don't think that the police should be. I mean, I know you need an investigator or an inspector or whatever, right? Inspector of police. You've got like these detectives and things like that, but actually, the grand juries are supposed to inquire into things. You know, obviously, there's a certain person with certain skills and things like that, but you know, they could always send investigators off. I think we've ended up with like we've ended up with like not only the police have got their own body investigating and controlling investigations, and then you've got the CPS doing it, so it's like two. And then, you know, when you're in court, they should just have someone like Patrick Gibbs, who's the prosecutor, who's been given the evidence, and he's got to make the case in court, right, and familiarise himself with the case as presented, right? Which they don't even do that now. Some Crown prosecutors don't even know what cases that they've got until it pops up on the computer screen, right? They're just reading it off the computer. They're not familiar with the case themselves. And in fact, it should really be voluntary. It shouldn't be costing it shouldn't actually be costing anything. It should be required, you know, for, you know, apparently there's a very low percentage chance of being called on jury, right? But there's meant to be grand juries called. It even says that the grand juries in Jersey are lay people forming part of the royal court. Historically, they acted alongside bailiffs to investigate crimes. But they've still got the police in Jersey. They've still got the Jersey police. I mean, what are they doing if the grand jury are inquiring into things? The grand jury was inquired to search out crime and present accused individuals to the court rather than deciding the final verdict. So there was petty and grand jury, and the petty jury actually do make a verdict and decide. Don't know what's the point of having a judge there. Both bodies operated as self-informing panels, meaning they did not just listen to evidence presented to them, but used their own local knowledge and investigation to bring charges. Right, so the current rules they've got on the jurors, right, is absolutely and completely inhibitive, right, prohibitive. And when that comes to, like, knowing the rights and liberties as well, there's a real serious issue, and Lammy's wanting to even get rid of them. So they were responsible for making the presentment, right? So, and they would just like pass it to someone probably like Patrick Gibbs or something, like a barrister. There doesn't appear to be any barristers in that William Penn trial, which is quite strange. See, preventing absolute power. Both served as a buffer between the monarchy, high authority, and the accused, ensuring the cases were brought not just arbitrary. You see, we don't have. I think the police and the CPS have been allowed to have absolute power now. The jurats evolved into a permanent panel of lay judges who sit with a bailiff to try cases and pass sentence, but that's only for Jersey. The grand jury remained a temporary group of citizens solely focused on determining if there was enough evidence to send a case to a separate trial jury. Grand juries were abolished in England in 1948. Well, actually, I thought it was 1933. It said. So in Jersey, they've actually got, like, the police now, basically, you know. So, like, in Jersey, they don't have, like, a judge. They have the jurat sort of instead of a judge, but there's more of them. Kind of like, but they were meant to do the work that all the police do now. So, but I suppose that, you know, they're meant to have different ones in different areas of the island, aren't they? So in Kent, it says, the historical example of the jurat of Maidstone. This oath was used to swear in the 12 jurats who supported the mayor serving for life and acted as magistrates. The full text of the oath, as documented in Gilbert's Antiquities, 1865, required jurors to pledge their loyalty to the Queen, uphold the town's customs and practice of the boroughs. Right, so the jurats are more like the aldermen and the permanent council, not the grand jury or the petty jury, but they're still sort of related to them. You shall true faith bear to our sovereign, the Lady Queen's Majesty, that now is her heirs and successors. So this is the jurats have got an oath of allegiance, kings and queens of this realm. You shall have that regard and respect into the mayor that govern this town and parish for the being as is fit, and the lawful franchises, usages and customs of the same parish. So they're meant to know all the rights and liberties and law. Advance and maintain this to your utmost power. So they've got to actually go out of their way to uphold the rights. And this one's an oath of supremacy, but the current juror's oath doesn't have that. And neither does the Common Councillors. The Common Councillors, ironically, don't have that oath. Only the aldermen, I think, had the oath of supremacy, and the same as much as you is from unlawful grievance and damage shall keep. So they're not allowed to have their own personal opinion in a matter. This is actually where the selflessness of the council comes in. Council's meant to be selfless, but how can, like, this is a thing with the current planning, right? The building and planning. If a council, and this is definitely for the local council, this with the mayor. This isn't the Common Councillors though, but this is kind of like the more like the aldermen, right? Which is like the main council, like the panel on the council, right? They're not allowed to have a personal opinion or grievance. Now, if the council want to redevelop the town centre, how can the council even want to redevelop the town centre? Because they're not supposed to have their own opinion on it, right? And if people oppose it, then how can they have it in front of the council, and how can the council vote on it? The council aren't meant to want anything with the council. So even when it comes to planning highways and things like that and stuff going through there, it's like, you know, even the design of it, sort of fair enough if the university comes in with a plan, right? But when they've got their own facilities and things like that, sports centres and all these type of new things, when they're doing planning decisions and applications and people are opposing it, how can they fulfil these type of positions where they shall not have their own grievance? Because, like, this is why I don't like ringing up or talking to councillors, right? Because our councillors now only take a very simple oath, right? Like very, very simple basic oath to perform the duties of the councillor. I don't like talking to councillors because it's always about something that's been done that I don't like or agree with, usually, and I'm always opposed to it. And there's always going to be a dispute, and then you end up falling out with the councillor, and then you haven't really got a councillor because then you can't speak to them, right? And they're the ones who are passing all these planning things, and they're supposed to be doing it impartially, supposedly. I don't know how they can do that when it's like, things that involve like things that the council own and operate. Because everyone's got a grievance with the council when the council's doing things that the people don't want. They've always got grievances with them. In fact, when the council are selling things off and the people don't want them to sell it off and they oppose it. How can you not enter into a grievance with anyone? Also keep as a freeman of this town and parish, you shall bear yourself for the good of this town, and is fit and convenient, so help you God. Amen. The freeman's oath, anciently administered in Maidstone. So that is effectively like the same as the other one that I've seen from Maidstone. So it definitely has got to uphold the liberties and franchises and laws. I'm going to see if they were ever connected to the grand jury or on the grand jury. Says that grand juries and petite trial juries operated concurrently in Kent as they did throughout England from the mid-14th century until the early 20th century. While the grand jury originated early around 1177, it became common practice to use both juries simultaneously for criminal cases. So you had a grand jury looking at the evidence, and then you had a petty jury trying it by the 1300s with a grand jury indicting suspects and the petit jury determining guilt or innocence, right? The sheriff in Kent, as in other counties, was required to return 24 men for the grand jury at the assizes and quarter sessions and to inquire into charges, while a separate panel served on the petite jury for the actual trial. So they were both called at random, but now they've got permanent police. They've got permanent police officers now controlling all evidence for an indictment, and the CPS. By the mid-14th century, it was forbidden for individuals who sat on the grand jury, presenting jury for a crime, to also sit on the petite jury. Also, they used to sit on both sometimes. So they did used to sit on both, but then they were banned from that. Concurrent operations, both juries were unused together for over 750 years. The grand jury would review evidence, bills of indictment, to see if a case was a true bill to be passed on the petite jury. The use of the grand juries in England, including Kent, was suspended during World War I and finally abolished in 1933, with final remnants removed in 1948, while the petty juries continued to be used. So we haven't even got the grand jury. We've only got the petty jury now anyway, and Lammy's even wanting to cut down on that. But so I don't actually think Lammy knows what the actual situation's reduced from and how severely questionable it is when we don't even have a impartial justice, because the police are impartial. It's a full-time job. The bailiffs and sheriffs are meant to be turning up at people's houses to arrest people, right, and lock them up, right? They're not meant to be under a chief officer controlling all the evidence. This is how they get all these monopolies and undercover investigations and, all these, now they've got them lobbying politically for their own, they want facial recognition, and they're all tied into an international thing. We've got, this is the regime. This is the regime that we've got, the military-industrial complex, and Lammy's wanting to get rid of it. This is all to do with Brian Leveson, right, as well. Brian Leveson submitting the recommendations when he's not independent. Brian Leveson's not independent. He's submitting an independent report, but he's in charge of investigatory powers, right? It should be grand juries who are applying for investigatory powers submitted at random because they want to find out something about a particular case that they're working on, selected. Instead, we've got all these, police, speech to the hand because the face ain't listening, right? Like callers will call you sort of thing, and the CPS who are controlling all the evidence and bringing and taking cases as they want and see fit. And we've ended up with it where they don't even acknowledge our rights and liberties for Parliament usage. And and after 1968, we aren't even getting courts officially even acknowledging that we've got cases to Parliament, and we haven't even got Parliament upholding the rights, privileges and usage of Parliament. I don't know what Lammy expects there to be left over. I think he just thinks like we're going back to mini kings, mini rulers, like, Brian Leveson, and Mark Rowley and Lammy are the supreme leaders, and they don't. Parliament doesn't even want Charles deliberating in the Privy Council anymore. Apparently, they even tried to remove the King from deliberating in Privy Council and things like that. And I don't know when these people like Lammy are elected. Lammy's like here today, gone tomorrow. He ends up working in some law firm doing some obscure law, like Max Hill. When Max Hill completely and totally, utterly was in contempt of Parliament with Angela Ditchfield, right? Max Hill orchestrated that appeal to the High Court on Angela Ditchfield's case when that was clearly an Extinction Rebellion political case, right? And, it's a regime, and I think it's the permanent ones who are probably, you see, like, people are getting elected in and elected out all the time. Like, we've got a different prime minister all the time, like Tony Blair or whatever, but he's still, vulturing around in the background on the parameters, doing dirty deeds overseas or whatever. I think the police are the main military industrial complex threat. And then you've got like the DVLA chief executives who will refuse to cooperate with us when we're doing investigations. When you're bringing a legal case, right, you're not like the petit jury or the grand jury or the jurats. When you go into a solicitor's and swear on a document, on an oath, like that's the jurat. They're making a jurat then, right? And you're bringing a case to either a local council authority, chamber, what's got the mace in it, or a court or whatever, and you're acting judicially. And when you contact the DVLA, like, oh, can I have some evidence? It's like, oh no, I'm not giving you it. I'm like, just a minute. They're not taking us serious. They're not taking the general public seriously. And this is when you've got these huge executive bodies like the DVLA, the Department of Culture, Media and Sport, etc. And they're just like flicking us like this, like, they're just flicking us. They're just flicking us like this, going, go away, like, flick, flick, flick. It's not like freedom of information, like, give me some information. It's like, when you're actually doing, and you're meant to be able to go to a court and get an order for a disclosure. It's called pre-trial disclosure. It means that if you're going to go to a court and you want to make a case, and someone's got evidence, and you're going to have to, they're not giving you it, you've got to force them to give you it, but they're meant to give you it. This is the thing, right? If it's like Coca-Cola, and you're prosecuting them, and you want the secret recipe, and they won't give you it, right? So therefore, you go to a court. So I think how they're wanting to do it now is they just want everything to be automated, because they're saying that machines can prove things, right? And the police and the CPS now do all the investigating work and correlation of evidence, but that's going to be done by the public, right? And totally impartial, without any prejudice or bias. But even now, they're starting to automate crime and justice with photographs and cameras processing that effectively can issue a fine or charge without even any police or prosecutor intervening in it, just purely automatic through a computer system, right? Except for someone like, putting a letter in an envelope, right? Except like even that could be machine. And they don't actually want the grand jury or the petty. You see, the petty jury was for the verdict. This is like impartial for the verdict. So the way they're going with firstly, first we had an impartial jury for the charges. Then they made it so they're not impartial. They're full time on the government, and they're a body, and they're under a military regime. And they all get trained and professionals, but yeah, it's a full time job. And then they've got like they become a political body that's lobbying for things. And then you even get rid of those, so you don't even have them anymore. They're wanting to just do it all automated by machines. And the verdict as well. They're wanting the verdict to be automated and possibly even not with a judge, right? But the verdict is meant to be down to some sort of human spirituality and conscience, regardless of what the facts are or what the people did or didn't do, right? And that's the thing that the government are in disagreement with, the conscience in respect of persons and their own individual conscience, right? Like in the like in the Ian Bray case, which they don't want that to be possible. The government want, you know, but there's a religious aspect in it as well. I've already done this bit with the sheriff.